Okay, that is an art of litigator. Post question, leave the room for discussion. Okay, and you will win your case. Alright, so thank you, Mr. Jason, for enlightening us further, hopefully. Okay, I see there are many things that we could actually put further to discussion with regard to all the points that have been throwing to us. Okay, so let us move to our next round. Okay, with all the points that have been pointed out, that have been given by our speakers. All right. Now, Associate Prof. Shamrahi. Now you have been talking previously with regard to this talk should be, or well, you have actually opened the view first that this would be actually the implementation of the Islamic public law. Alright, rather than talking about Islamic personal law, since our law are very clear on that. Okay, our law in Malaysia, we have no issue with that to Islamic personal law. Okay, everyone can profess, can practice their religion, can practice their personal law without any impediment. Okay, without any problem. Okay, but when we talk about this Islamic public law, okay, we are also talking about states. Okay, and some probably some had raised issue of, is it because of our state? Is it because of the nature of our state that actually restricted this implementation of Islamic law? Okay, we heard about the debate on Islamic State, okay, politically or academically, alright, we have been listening, we have been confronting all this debate, okay, whether Islam or whether Malaysia is Islamic State or not, okay. Is it because of that? Is it because of our confusion with regard to the nature of our state? We need to be an Islamic state, we need to be a totally Islamic state, then only we could actually implement Islamic law? Or is it enough to what we have right now? Is there any exit to this debate, or any reconciliation to this debate? Maybe you can point us, can enlighten us with that, please.
Thank you for the questions. We are looking for reasons why we don't apply Islamic law. Is that the reason of the question? The main reason mentioned is because of the nature or the character of the states. In my opinion, if we look at all kind of legal system, we determine what the legal system we want to have. If we go back to the time when we achieved independence and we formed the constitution, what was the intention of our constitution? What is the philosophy? What is what we call the main objective of this country as far as the legal system is concerned? So we have very clearly provisions in the constitution that mention we having Islam as a religion of the religion of the federation. We have the legal system, dual legal system, the Sharia law, Sharia courts, and we have the civil law and civil courts. So these are the legal systems that we want to have. We were not in the process of independence. We were not talking about whether there must be Islamic law in public arena, in a public as Islamic public law, but to looking at the provision to see that the character of the state itself is not, it's not one of, to my mind, it's not one of the reasons why we cannot apply Islamic law. Because as long, we don't have to mention that this is an Islamic state, then we want to adopt Islamic law, or want to apply and implement Islamic law. It's not necessarily so, because the legal system, I will go back to my foundation, or my principal point, is that what we are going to achieve in the legal system is justice. So if we think, if we believe that the constitution that creates the legal system and creates the character, the philosophy, the ideology of the country wants to have Islamic law, it can be applied. We don't have to name this an Islamic state. But the principles of Islamic law is already there the objective of Islamic law is already there in the legal system. I have to put a strong statement here. 90% of the law here in Malaysia are already Islamic. Why I say this? Read 90. If reading criminal law, reading all criminal legislation, including Akta Hasutan. There's some values that we can have Islamic point of view because let's say Islam does not allow feeling of enmity, does not need to instigate feeling of enmity. You cannot do that, but Islam support that. All provisions in the penal code are all ta'zir or discretionary punishments, discretionary offences. Similarly, mandatory death sentence for DDA, Dangerous Drugs Act 39B, it can be Islamic. Mandatory death sentence may be Islamic to one mazhab. Therefore, we don't have to label this country as an Islamic state that we want to apply Islamic law. What we don't have, Islamic law that we do not have in Malaysia, is punishment for those offences. That's 7 offences. That's considered as hudud offences. And punishment for, alternative punishment for killing. We don't have compensation or diyah. Let's say, what we call in Islam, in the Arabic terminology, is qisas. Qisas means retaliation. If you kill somebody, you also be killed. Intentionally, then you'll be killed. If you cut somebody's ears, eyes for eyes, ears for ears, that is retaliation. But in Islamic law, Islam allows and encourages forgiveness. If you forgive and the other person has to pay compensation. Let's say you recklessly driving recklessly. Then you hit somebody and he died. That is considered a killing, unintentional killing. And you have to pay compensation to the family of the victim. That particular person who caused the killing has to pay compensation. But we do not have that in Malaysia now. So the victim will have no damages to claim from the offender. But Islam allows that. I think this is a very beautiful principles of law. But you give choice. If you have to forgive, never mind. Let's say somebody intentionally killed the father of 6, the only breadwinner of the family. So if the family says that it's fine, then you forgive that. Forgive him. But this person has to pay compensation. That's what we call diyah, or blood money. So these 6 children whose father was killed will get some benefits. So this is the beauty of Islamic law, but it's not there in Islam, in our Malaysian law. So the only thing that we do not have now in Malaysia are punishment for those who do offences and that retaliation and diyah or compensation. So we don't need to have to label that this country an Islamic country. I would say that there are some similar objectives between Islam and other system of law, some similar objective to achieve justice. But what is justice? What is justice according to Islam, and what is justice according to non-Islamic legal system is different. Because Muslim believe or Islamic law believe in the punishment and rewards in the hereafter. But the current legal system does not have that. However, in the implementation, justice is seen to be done because there's also a situation from the sociological point of view, because in making the law, we cannot only look at the legal point of view. In making the legal point of view, we must consider the sociological point of view. So what is the sociological point of view is that we must accept also customs. We must accept also the practices of the community. So, to answer the question, my opinion is that we don't have to label this country as an Islamic state. Only then we want to practice Islamic law. Second point, that we already have Islamic law in this country. And third point is that we can improve the implementation of Islamic law to making it acceptable by the multiracial community. There must be justice within the community, that the community share the values of justice. Not only justice because it's my religion, then the law becomes justice. But let's say we are Muslims, then we think that it's our belief that we have to practice hudud offense, hudud punishment, that alone will not make sure that justice is actually be done. But we must go through the process. We must prepare a very comprehensive law to make sure that it's actually will be achieved, that justice will be achieved. So the idea is that if we want to have a legal system, it must be a legal system that is acceptable by all. Law cannot be alien. Law must be acceptable by the community. Allah.
Thank you, Dr. Shamali, for her response. Okay. Yeah.
Sorry, I just want to on the points raised by Sham. On the mandatory death of the DDA, the mandatory death penalty for drug trafficking offences, the very case of Cik Omar Jessup was on point for that case. In that case, it was argued before the Supreme Court that it is against Islamic law to impose the death sentence to a drug trafficker because it's not one of the not one of the classes of offences. Of course, the Supreme Court said no. If you want to read up on that, there is also one other article by Associate Professor Azman Muhammad Nur on penyalahgunaan dadah dan kewajaran peruntukan hukum masyarakat atas penagih dan pengedar dadah di Malaysia menurut perspektif syariah. This article you can find at the AABK website, Agency Dadah Kebangsaan. Wonderful. It's a good it's a good balance. After you read Cik Omar Jessup, you read this article, it gives you a little bit broader perspective on that. The first point. Now, on the point of dia, now I have to admit, I really am interested in dia. I really love the concept. It covers blood money. Okay. Now, dia, and please correct me if I'm wrong. At any point, just jump in, please. Dia works on the basis: if you kill someone, the family of that person has a right to ask for retaliation, an eye for an eye. If you die, if you kill someone, you are liable to be punished with death. Alternatively, you can pay money so that you don't die. Why is this attractive? Because, let's put it like this. Someone, let's say your father, someone in your family gets killed. He has a wife, he has children. If the killer dies, who's going to take care of the children? Who's going to beri makan minum? But so the choice is on the victim's family. You can choose, he killed my brother, he should die. You can choose one, or you can choose two. Tanggung his father, tanggung the children that are left. The choice is on the victim's family. That is what is attractive about dia, which should be explored further. Now, this concept is not really that alien in Malaysia. It actually has similarities with the thought of negligence. Now, in the thought of negligence, specifically for running matters, road accident cases, it's like this. You cannot accident, patah kaki, right? You patah kaki, you cannot work for it for 3 months, 5 months, 6 months, right? You claim for your injury, patah kaki, and you claim for your loss of earnings for that 5 or 6 months. You can't work, you dapat gaji, so you get the compensation for that. That's compensation. Now, what if you die? If you die, it's considered a fatal accidents claim. So if you die and you can't work, you can't give money to your wife, your kids, or your parents, your own parents. They, as your dependents, can make a claim of loss of dependency against the person who langgar. So, what's the difference? In one case, you kill someone, you have the concept of dia. In the thought of negligence, fatal accidents, you have langgar orang sampai mati, you pay for the dependency, loss of dependency for his dependents. These are concepts which are not alien in common law or the thought of negligence. It's not alien. It's just a matter of where do we find common grounds and let's work towards it. Let's see where we can find. Professor Shah is probably right. That if she says 90%, with what I've just suggested, perhaps it's a little bit more than that. Perhaps. But then again, dia is going to be a very difficult idea to propose. But those are the lines which can be drawn. Sorry.
Thank you, Mr. Jason. Very interesting. Very interesting to know that Mr. Jason is also interested with regard to this point, which Mr. Jason also have actually pointed us. Okay, how the society perceive hudud. Okay, there are people who opposing hudud. There are people who support hudud. Okay, and it across the line. Okay, regardless of races, regardless of gender, regardless of status, and so on. And in another point, okay, everyone are happy to accept and to practice Islamic banking, okay, without any doubt, okay. They happy with the system. So, Mr. Jason, for my question, so we see clearly just now that there are views, there are opposing views with regard to the implementation of hudud, i.e. the Islamic public law in Malaysia. But there are also things which is accepted by people in our multiracial nation, okay, and it is an Islamic part of Islamic law. So plus what we have just mentioned just now, okay. So in your point, in your opinion, actually, is there actually really a clear and a definite impediment in terms of implementing Islamic law in Malaysia? Okay, is it what if there is any impediment? What would be the real cause actually, in your opinion, as a legal practitioner?
Yeah, to be honest here, I did sort of insist that the organizers tell me, what are you going to ask me seriously? I was like, come on, seriously, I'm a non-Muslim, I'm talking about implementation of Islamic law, seriously. You cannot let me go there naked. Come on. It's okay.
You are at that point. Yes, you are already at that point.
Okay. So, the specific question, are there conflicts, dilemmas, are there obstacles to implement Islamic law in Malaysia? What are the impediments? Okay. First point, you always must remember the Constitution. Everything in Part 1 of Schedule 9 in the federal list is off limits currently. It means criminal law. That's off limits. Now, hudud is criminal law. Now, states cannot legislate on it because hudud offences are similar to penal offences, and it is provided if it is provided in the penal code, there cannot be a replication of that in the hudud in Kelantan or in any other state. That is the first clear impediment. Schedule 9, this one, this two. And that's in Article 74, 75, 76. Second impediment is the Sharia Courts, in brackets, Criminal Jurisdiction Act 1965. Now that's the act that provides the formula of 3, 5, and 6, which states that Sharia courts in all states shall not exercise jurisdiction for more than 3 years, imprisonment of more than 3 years, or more than 5,000 ringgit fine, or whipping of more than 6 strokes, or any combination. Now that's the limit that is imposed by the 1965 Act. Now obviously, amputation of limbs, amputation of the hand or legs, and stoning, it's definitely out of that framework. Third impediment. Do I have time? Okay, if I have time, I'll read. It's in the case of Latifah Matzin itself. Okay, the judgment of Tun Hamid. It's at paragraph 78 to 80 of the Latifah Matzin decision. Now he explains the background to it. Why is it difficult? The background is like this. The Constitution was made 50 years ago at a time when the Muslims in the then Malaya were mostly Malays living in rural areas, working as farmers, rubber tappers, fishermen. Marriages were usually within the village or the district. Intermarriages, cross-cultural lines, were rare. Conversions to Islam were equally rare. In fact, anyone at that time who converted became a Malay. It was called Muslim because of Islam. And for those of you who are old enough, you know what it means. That was how it was perceived. So the houses of Pencarian were limited, confined to plots of rice land or rather small buildings in the same district. Now the Constitution, Malaysian Constitution, was drafted under those circumstances, and it was to cater for such conditions that the Sharia court was established. Now, no one could foresee that the Sharia court, in its position as a state court, would have an expanded role. And it's all that. Now we have intermarriages, now we have conversions and reconversions. And I'm using the word reconversions because it's in the judgment. It was actually noted in the judgment of Latifah Matzin. Malaysia went from an agricultural economy to a now industrial economy, and now we're moving to a post-industrial knowledge economy. Things have changed. We have jurisdictional problems that were never envisaged at that time. And some require double proceeding. So, like in the case of Latifah Matzin, we have to go back to the Sharia court to get the to decide on the question of hibah. And sometimes you also have to just by right, you still have to get how the division will be done for this decided by the Sharia court. If, and this is the hard part, if one party is Muslim, one party is not Muslim, we have a deadlock, which a lot of the controversial cases are involved. Let me end with what Tun Hamid said in Latifah Matzin. It is for the legislature. It is for the legislature to step in, to decide as a matter of policy what should be the solution and legislate accordingly. Because our judiciary is not an activist judiciary. They interpret the law. This problem is a legislative problem. It should be fixed at the legislature level. It should be fixed at that policy level. Now, if we go back a few paragraphs, in paragraph 47 of the Latifah Matsin decision, he identified the problem. The problem is everyone looks to the court to solve the problem of the legislature. Judges too, including myself, unwittingly took upon themselves the responsibility to solve the problem of the legislature because they believe that they had to decide the case before them one way or the other. That, in my view, is a mistake. The function of the court is to apply the law, not to make or to amend a law not made by the legislature. Knowing the inadequacy of the law, it is for the legislature to remedy it by amendment or by making new law. It is not the court's function to try to remedy it. Now, this is where my answer actually goes off from the legal view, and it goes a little bit to the realm of politics. Now, at the current composition of the Dewan Rakyat that we have right now, as it stands, this is the political reality. It does not seem likely that there will be a legislative change to amend the Constitution, nor the 1965 Act. Why? Because it will be an exercise in futility. Now, theoretically, it may happen. Theoretically, it may happen. Consequences are scary. Why? Let's say the two Malay parties, UMNO and PAS, join together, and they have a few other smaller parties. They join together. They get simple majority in parliament. Okay? They get the bill passed. No problems. What's going to happen? Newton's third law, a reaction, equal and opposite reaction. It applies in physics, it applies in social situations too. What will happen? You will know for sure PAP, MCA, MIC, and liberal-minded people, they will oppose it. There will be a redesignation. New alliances will be formed, new political landscape will emerge, Malaysia will change. This is my opinion, not political. Because it will be now a split between Muslims and non-Muslims. Come on, that's not us. That is not good. Because when you split between Muslims and non-Muslims, remember this, when India got its independence and Pakistan split, 500,000 people were killed in the ensuing violence, 14 million people were displaced. Now, if that is repeated in any way in Malaysia, and probably won't because our population is smaller, even to a lesser degree, if that is repeated, that's disaster for us. And this was the chaos point that Tun Mahathir pointed out. The impediment to implementation of goodwill in a multiracial, cultural, multiracial, multireligious society, it's not multiracial. The impediment is injustice. Remember, we have Article 8, Clause 1 of the Constitution, all persons are equal before the law. Okay? You cannot discriminate on the grounds of religion. You cannot have hudud laws that only apply to Muslims under the present Constitution, because that would be unconstitutional. And I think I'll just stop it at that because I think I got the point through, right?
Okay, thank you, Mr. Jason, for answer just now. Okay, I think that gives us some view and some thought with regard to the last point on justice. Okay, now we go for our third round. Okay, and I think hopefully this will be a very lively session where I would like to invite the audience, the floor, to raise and pose any question to our panelists, so that we maybe not necessarily question, maybe it's opinion. Okay, as long as it is try not to be very provocative and Okay, try to be academic and intellectual. Okay, so I will now open the floor for Q&A session. Okay, we will collect the question and then the panelists will then answer collectively. Okay.
Assalamualaikum warahmatullahi wabarakatuh to all the speakers and also my fellow friends here. I'm Siti Fatima binti Azman and I'm second year law student. I'm going to ask two questions and this question is I'm going to ask to Professor Shamrahayu. The first question is yeah, we know that religion is put under the state matters, which is stated under list 2 of the 9th schedule of the Federal Constitution. And what I'm going to ask to Prof is, do you think the religion matters which stipulated under list 2 of the 9th schedule of the Federal Constitution make it difficult to the legislature to legislate hudud on the 7 Sharia criminal offences? This is my first question. And the second question is, I do agree with what Professor had stated just now, which is 90% of the Malaysian statutory laws are Islamic. But I do think that most of the Malaysian has lack of understanding on it and lack of awareness. And I just want to ask to whom we should ask for to make the Malaysian understand about it, about the 90% statutory laws are Islamic. And that's all. Thank you.
Just raise your hand for question, alright, so that the mic can go around. You need to be ready.
Hello. Good evening. As two speakers have just introduced to us the reactions, mostly we are discussing on the reactions of the Malaysian toward the implementation of Islamic law in Malaysia. But we also have to understand Malaysia as a country which is heavily depending on the foreign investment. But to what extent in the present context as Malaysia is being invested by the West, for example the Europe country and the United States, including China. If the implementation of the Islamic law in this country, how far will it affect the income of this country? What will be their view from the West, and what is the view from the other part of the country toward the implementation of Islamic law? The second question is, as we have learned in the Islamic law principle, as has been suggested just now, the Islamic law and the Malaysian law is the same as 90%. However, to a certain extent, as we have learned from the law, in order to satisfy a charge, we have to satisfy the elements of the crime. For example, the actus reus and the mens rea. Is it the same in the Islamic law? The elements is exactly same as the penal law offences. And secondly, toward the criminal procedure, is the evidence to procure an evidence, to establish an evidence, is it the same way that the Malaysian penal code offences and the Sharia offences in order to satisfy the element, is it exactly the same? There are only the two questions that I would like to ask. Thank you.
Thank you.
Yeah, Assalamualaikum warahmatullahi wabarakatuh. My name is Al-Nazri and I'm not law student. Okay, first question I would like to ask Mr. Jasingi. First, for the statistic that you show to us, the respondents are aware about what hudud is really, oh my god, my grammar again. Okay, no, my grammar. Okay, are they aware about what hudud is really are? It's really. Okay, because like, in reality, there's like someone are trying to scare the people that hudud is not good. Hudud like, if you steal, you will cut your hand immediately, and then like if you kill people, you also got some punishment. If you drink alcohol, you get caning, like that lah. And then second, I will shoot my question to Prof, which is the value of for the test, is the value of the team will depend on the sentence. I mean, like if we steal chocolate 20 cents, and if we steal a car for I think 5 million like that, and then if both criminals are also need to cut the hand, or if very varies. That's all my question. Thank you.
Okay, maybe one more question, and then we will, or two more. Okay, go. I get the question.
Assalamualaikum and a very good evening. I'm Aina Munira, third year law student. First of all, to Mr. Jason K, I really like your recommendation on how to implement hudud in Malaysia, whereby we have to do it gradually, like what's stated in the Quran about the prohibition of alcohol. So I'd like to ask whether if you can further elaborate on what do you mean by gradually, whether the hudud is implemented by state, or in what sense did you say it's implemented gradually, like the prohibition of alcohol in the Quran? Thank you.
Next, yeah.
My name is Zach. I just want to give you a scenario. Since all of us think that the reason why most people don't want hudud to be implemented is because it's severe punishments, right? So what actually is that we have been looking at this the wrong way? What is the reason that why people do not want hudud to be implemented? It's not because of the punishment itself, but it's because of the situation in Malaysia, like how non-Muslims perceive the Islamic State administrators. You know how they have been infringing their liberty rights and so on. And how about that? Like there are officers who are actually corrupt and all that. So it's not about how because the point of hudud is still at the end of the day is to if you do wrong, then obviously you get punished. So there's nothing wrong with that. I think everyone can agree that no matter what's the punishment, but because of the situation of official Malaysia itself. So what do you think about that?
One before we wrap up, two before we wrap. You and another girl. It's okay. You can post question or.
The question is directed to Dr. Sham.
Yeah, it's okay.
But she's not here.
No, it's okay. I'm writing the question.
My question is this. It's basically based on the physical conception of punishment.
Sorry?
As we know, Islam has a very has very visual forms of punishment. The amputation of limbs, stoning to death, etc., etc. As we know, the attitude of the legal world right now is to move towards more humanistic, more humane forms of punishment. In the Western world, for example, punishment to death has moved from hanging to the guillotine, to the electric chair, and finally to lethal injection. We will try to keep it as painless. We will try to make it as painless as possible for the wrongdoer, because the aim of it is to remove the wrongdoer from society. And when he is a psychotic killer who cuts people up and eats them, he can no longer exist in society. He has to be removed, but in a humane, painless way. Now, Islam has punishments such as stoning to death and amputation of limbs, which even Muslims will agree sometimes that it may seem a little Quentin Tarantino-esque. Now, my question is, if we were to implement hudud law, but we were to alter the punishments, like such as if a person is to be sentenced to death by stoning, can we sentence him to death by lethal injection or by poisonous gas? Gas chamber. Can you choose to pick, to cherry pick from Islam? Like for instance, many Christians do this. They pick certain parts of the Bible that they like and ignore parts that say nasty. Can we do this in Islam? Can we implement the death punishment, the death penalty, but instead of stoning the fellow to death, we just inject him with poison? Is that alright? Or must we follow it as stated in the Quran? That's my question.
Okay, that's all. We'll go maybe in the back, and then we will, if we have the time, I will open again. But I think we have. Yeah.
So my question is really short. I'm a foundation law student. It's more of a personal opinion, so it's directed to both Prof and Mr. Jason. So, why do you, based on the statistics that Mr. Jason gave on the implementation of hudud, why do you think that Muslims in Malaysia seem unready? Because of the statistics, about
Why
58%.
Muslim or why non-Muslim?
Muslims in Malaysia are not ready. Personal opinion. Thank you.